Good morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair. Chair, today and tomorrow have been reserved for the evidence or further evidence of Mr. Fuzile and Catherine McLeod from Treasury. The issue has arisen in relation to the cross-examination of Mr. Fuzile by the representatives of Mr. Van Rooyen. That issue you have directed should be dealt with at the start. And then after that, Chair, the evidence this week and in the next 2 weeks will be led in relation to the matters relating to Eskom. Mr. Maleka will deal with today's proceedings, tomorrow's proceedings, and will lead the team in relation to Eskom.
Okay, thank you. The applicant or counsel for Mr. Van Rooyen.
Chairperson, for the record, I am Homuswane Matipa. The initials MK, the surname Matipa.
Thank you.
I'm led in this matter by T. Masugu SC, who couldn't make it today. Right. From our understanding, today at this time was meant to move the application for leave to cross-examine Mr. Fuzile, an application for leave to give evidence by outline Mr. Van Rooyen, and thirdly, a condonation application. We will be guided by you, Chairperson, with regard to how we deal with this aspect, mainly because we are in the process of completing a supplementary statement for our client in relation to the areas that were pointed out to us that needs to be addressed. So by the end of today, it will be ready.
Yes.
And from what I picked up was your suggestion could be that it be submitted first before we move this application, because it relates there too. So I would be guided by you, Chairperson, there.
Well, Mr. Van Rooyen submitted or delivered his application for leave to cross-examine Mr. Fuzile some time back. I had occasion to read the application at some stage last week, and there was an issue that I thought ought to be addressed by him in an affidavit or supplementary affidavit in regard to his application for leave to cross-examine. I requested the legal team to mention that to Mr. Van Rooyen's lawyers so that they could apply their mind to it as to whether they accepted that it's a legitimate issue to address. I understand from what you have said that indeed Mr. Van Rooyen and his legal team have no problem addressing that issue in a supplementary affidavit, and that supplementary affidavit should be available at some stage today. Is that correct?
That's correct. I confirm that, Chairperson. Yes.
Now, it would not be appropriate to, I think, deal with the application for leave to cross-examine before we have that supplementary affidavit. And it is possible that once that supplementary affidavit has been received, by the legal team and by Mr. Fuzile's lawyers. It may well be that they might decide that certain allegations that may be made in it need to be investigated, or that they may need to file some affidavit in response to them. And it seems to me that that scenario places us in a position where it would not be appropriate to deal with the application for leave to cross-examine at this stage until all of that has happened. Do you have anything to say about that?
Chairperson, nothing to say except to say that I agree with the approach that you propose be taken, so that we then submit the supplementary affidavit. We had actually thought, and let me just mention this while I'm still on the floor, we had actually thought the reference to supplementary affidavit was inadvertent reference to supplementary statement. Because we thought,
okay.
yeah, because he had submitted a statement, so we thought, in that regard, what we're really preparing is a supplementary statement.
Well, you just need to look at the rules. My recollection is that the rules require you to make when you make an application for leave to cross-examine. My recollection is that what's contemplated is an affidavit. I may be mistaken. Just apply your mind to that.
I agree, Chair. Sorry to interrupt. I agree. We actually have submitted an affidavit in relation to the application for leave to cross-examine.
Yes.
Yeah. So
yes.
when the information came to us to request more information,
Yes.
we thought it was in relation to the statement rather than in relation to the affidavit for the application to cross-examine, to leave to cross-examine. So now I understand.
Yes. Yeah. You see the issue that you were asked to consider addressing in a supplementary affidavit, which you understood to be a statement, is an issue that's relevant to the application for leave to cross-examine. And my inclination is that it should have been dealt with there. But I can understand if those who prepared the affidavit might not have appreciated that it was important. But it's a factor to be taken into account in regard to the application for leave to cross-examine. Yeah. Yes.
Yeah. So I think all we will do is to convert it into an affidavit.
Yes.
Then
yes.
it shouldn't be a problem at all.
Yes.
Yeah.
Okay.
Thank you.
Okay.
Yeah.
Well, I'll hear what everyone else may have to say, but it may be that all parties may well indicate their attitude as to whether, if I see fit, I could deal with the application for leave to cross-examine in chambers as opposed to in an open hearing with argument. But obviously the decision would be announced in an open hearing. That might just help expedite things, but obviously if we are to deal with it that way, it would be important that everybody concerned must have an opportunity to put in whatever submissions they might wish to put in. I don't know whether you are in a position to indicate what your attitude is to that, or is it something you would need time to reflect on?
No, we definitely would support that approach of resolving it in chambers and then announcing it later.
Yes.
What was communicated to us by the legal team is that they will not object to the application for leave to cross-examine or testify.
Yes, 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 yeah.
Yes.
Okay, no, that's fine. I don't know whether I should be counsel for Mr. Fuzile or Mr. Maleka. Yes. Oh, your mic. Yes.
Thank you. Mr. Fuzile is under subpoena to attend the commission today and tomorrow. He is no longer in the employment of National Treasury. He's left other work responsibilities to assist the commission over the next 2 days. He's indicated and instructed that he's willing to subject himself to cross-examination by Mr. Van Rooyen's legal team today or tomorrow. And so he's available and would prefer that the cross-examination takes place either today or tomorrow. We are also instructed by National Treasury to bring a substantive application to cross-examine Mr. Van Rooyen. We haven't submitted that application yet. We are still within the time frame of the 14 days in terms of Rule 3.3.6 of the Rules of the Commission, and we will be submitting such application within the allotted time frame. And we are in your hands, Chair, as regards the cross-examination of Mr. Fuzile in the meantime.
I do understand from last time that Mr. Fuzile is now with new employers who are not part of the government. It's important that the processes that we follow be fair. It seems to me that while the legal team certainly of the commission certainly wanted to accommodate concerns that Mr. Fuzile or his employers may have and try and finish his evidence and cross-examination within these 2 days, at a practical level, that's not possible without the commission acting unfairly. Mr. Van Rooyen and his lawyers had prepared an application for leave to cross-examine that they believed was in order. I'm the one who raised a certain issue to say they should address it, and they are addressing it, and they'll put in a supplementary affidavit. They say to the extent that they thought it was a statement, it would be available sometime today. I don't know whether the fact that it's now going to be converted into an affidavit might cause a delay by 1 or 2 days. But that supplementary affidavit is important for purposes of considering his application for leave to cross-examine. And the application should not be dealt with before that is in place. Obviously, you have heard what I've said about the whole thing. I think that I should just say to Mr. Fuzile, I hope his new employers will understand the importance of the work of the Commission. There is nobody who is dragging Mr. Fuzile to the Commission unnecessarily. And from what Mr. Fuzile has said before, he is willing to assist the Commission as much as he can. My understanding is that there may be challenges because he is with a new employer. I hope that somebody can just explain to the new employer the importance of the work of the Commission. Mr. Fuzile was occupying a very senior position at Treasury. He has information that is going to be useful to the Commission in dealing with its work. So the new employers must just show an appreciation of the importance of the work of this commission and allow Mr. Fuzile time to assist the commission. It's not like we want him here like every week. After tomorrow, arrangements would be made for another time. I just want to emphasize this point, both in regard to Mr. Fuzile's employers and other parties. We have been trying as a commission, as far as possible, to accommodate people in regard to dates. But we can't do that all the time and forever without compromising the speed with which we must do this work. So there are going to be times when various people are not going to be happy with us because we are going to insist on certain dates. This commission has a very limited time within which to finish its work. And if we were to accommodate everybody, we would never finish. So everyone will have to show appreciation and understanding. That's going to be the case with counsel, with lawyers. That's going to be the case with witnesses and employers of witnesses. We'll just have to show appreciation that the work of the commission is work for the country. They are doing business in the country. They want a better country, and this commission is about making a contribution to the building of a better country. So all of us must make sacrifices. So I just thought I would mention that. So, but from what you say, it seems to me that you can't do anything more than record what you indicated, but you understand what needs to be done.
Chair, I fully appreciate what needs to be done and the constraints of the Commission.
Yes.
And for the record, National Treasury,
Yes.
The attitude of National Treasury is to fully cooperate with the
Yes.
Commission,
Yes.
both in the
Yes.
provision of written evidence and
Yes.
appearances,
Yes.
and that remains to be the case.
Yes.
As far as the cross-examination of Mr. Fuzile goes, I've made my submissions.
Yes.
I'm in agreement, and I would support the Chair's suggestion of an expedited process for the application for cross-examination to take place.
Yes, yes.
Through a Chamber's application,
Yes,
perhaps.
yes.
And if it is possible to do that within the application to take place, at
Yes,
least within the
yes.
next 2 days, and for us to
Yes.
respond, that would also be our preference.
Yeah.
I understand there's a supplementary affidavit to be filed. If that could be
Yes.
done today, we would be in a position to respond tomorrow.
Yes.
So
yes.
we are here and present and
Yes.
accounted for.
Yes. And with regard to Mr. Fuzile, once it's accepted that there is a legitimate issue that has been raised, and I can just tell everybody what the issue is. The issue is that in terms of the public protector's report, the public protector indicated that there were cell phone records which indicated that round about the time or immediately before Mr. Van Rooyen's appointment, certain cell phone records reflected that he was around Saxonveld or visited the Gupta family a number of times. I think it's important that I should know what he has to say about that. Is it true? Is it not true? Or what the version is? That's the issue I have raised. So it's an important issue, and he should be given enough time to deal with it. And once he has dealt with it, it may well be that both the legal team as well as Mr. Fuzile might want to respond to what he says, if we are going to do justice.
Yes.
Okay.
Yes.
All right. Thank you.
Chair.
Mr. Maleka?
Chair, I hope what I'm going to say does not upset the apple cart.
Yes.
We would suggest that there's a middle ground between the two extreme positions proposed on the one hand by the lawyers of Mr. Fuzile, and on the other hand, the suggestion proposed by the lawyers of Mr. Van Rooyen. And the middle ground that we would ask you to explore arises from the powers you have in terms of the regulations to consider and, if necessary, grant leave to cross-examine only if it is in the best interest of the work of the Commission. So we underline the prerequisites of that power you have. And as you consider all of these questions, as you navigate between the two extreme positions, we would ask you to consider what is in the best interest and the work of the Commission. We understand that there is a need to be fair to Mr. Van Rooyen, but we would ask you, as we consider the question of fairness to Mr. Van Rooyen, that we are in this difficult position because of the attitude he has taken and the attitude which arises from his papers before you. There is an application for condonation because his application for leave to cross-examine and his application for leave to testify come almost a month later than the time period he was required to submit that application. So we are in this difficult position because he has decided to make an election in terms of the rules a month later than he was required to do so. And so fairness requires that as you consider the conflicting or competing interests, take into account that we are in this difficult position because of the late choice he made.
When was his application for leave to cross-examine delivered to the Commission?
Chair, you now have before you the bundle comprising the statement under oath, not under oath, a statement by Mr. Van Rooyen responding to the evidence of Mr. Fuzile and others who corroborated that evidence. Somewhere in the middle of that bundle, there is an application for condonation.
And it should actually have been at the top.
It should have been at the top, but it's somewhere in the middle of the belly of that bundle. You will see that the application for condonation is prefixed by an index, and you will see that the last part of that index bears the date of 25 January 2019.
Yes.
At best for him, the application was made on the 25th of January 2019. If you go to page 22 of that bundle, you will see that there is annexure DD1 of the application for condonation. There's the Rule 3.3 notice that was given to Mr. Van Rooyen at the request of the legal team of the Commission, informing him about the nature and extent of aspects of Mr. Fuzile and others who corroborated his evidence, which may or could implicate him. You will see that the notice is dated 19th November 2018. That is on page 25 of the bundle.
Well, my page, well, there are, my page 25, there are two pages 25s. and both of them don't reflect a notice from the Commission.
There is Annex DD to the application for leave to condone.
Yeah, but anyway, you say the date is November, is no sometime
19 November 2018.
Yes. Yeah.
So taking the two dates together, the application for leave to cross-examine and or lead evidence is out by at least a month. And so we are in this difficult position because of the lateness of that application. So that we would submit that if ever there's going to be fairness in order to allow Mr. Van Rooyen to cross-examine Fuzile, it must take into account the fact that he was late. It must take into account the fact that people like Mr. Fuzile, and of course we, the legal team of the Commission, would be prejudiced by reason of the fact that he did not comply. So the level of prejudice that I would want you to consider in order to explore the middle ground is this. Firstly, that Mr. Fuzile is here to be cross-examined. He has made it quite clear that he's here today and tomorrow. And for that reason, we would like you to consider that part of the balancing exercise. I understand that it is important for him to make as much contribution as is necessary to assist the Commission in its work. We ourselves have prepared to complete his evidence in relation to that discrete, narrow part of the terms of reference, which is paragraph 1.8. It is fairly narrow, it is discrete, and it can be completed because on that term, the only outstanding evidence as far as we see it is that of Mr. Fuzile, and it is that of Ms. Catherine McLeod, it is that of Mr. Van Rooyen. That completes the evidence in relation to paragraph 1.8 of the terms of reference.
Yeah, but I'm not sure to what extent you as the legal team are ready to deal with Mr. Fuzile's, not Mr. Fuzile, Mr. Van Rooyen's version. If you tell me you are, I'll take that. But I don't know, and I haven't seen anything here that suggests that we have statements or affidavits from relevant persons in regard to those cell phone records that the public protector talked about. I don't know whether there isn't any investigation that the investigation team is doing around Mr. Van Rooyen, among other people, to check certain things, to enable you to deal with certain issues properly. So, but I hear what you say, but in the end, I think logistically, there's difficulty in doing this over this and having Mr. Fuzile considering the application for leave to cross-examine before the supplementary affidavit is in, and when it is in, depending on what he will be saying in it, you might have need, as the legal team, to approach the person who produced the cell phone records and say, what do you say to this version? And so on. So when the application for leave to cross-examine is considered, obviously including the condonation application, such delay as may have happened on the part of Mr. Van Rooyen will be considered and dealt with. But logistically, there is difficulty in dealing with that application until everything is in.
Yes. I understand, but can
Yeah.
I tell you the position
Yeah.
of the legal team? And I
Yeah.
hope I'm not misrepresenting my colleague's position.
Yes, yes.
And the position arises from this context. Neither Mr. Fuzile nor his former colleagues in Treasury raised the question of the cell phones.
Yes,
The question of the cell phone arose for the first time in the Public Protector's report.
yes.
You would recall that part of the bundle you have
Yes,
from Mr. Van Rooyen
yes,
includes the application for an interdict
yes.
against the
High
release of the
Court.
Public Protector's report.
Yes, yes.
In parts of that affidavit,
Yeah.
he deals with the question of the cell phone records. He doesn't squarely deny whether the Public Protector's reference to those records is accurate or not.
Yeah,
The position he took at that point in time
yeah,
was that until he sees that records,
Yeah.
those records,
yes,
he would not be able to comment.
yes,
When you raised with us the question of the cell phones
Yes.
and asked us to inform him about that issue
yes,
so that he can make a choice to deal with them in the supplementary statement,
yes,
we prepared ourselves to deal with that part of the omission.
yes, in a
Should-
certain way.
In a certain way.
Yeah.
We can assure you that as far as the investigators are concerned,
Yeah,
they've done the investigation.
yes,
In the trial bundle that we were going to hand up to you,
yeah,
we have included several cell phone records
yes,
relating to the various communication activities
yes,
that took place during that period, before and after.
yeah.
So we are ready to
You
deal
are ready.
with that issue.
Okay,
Should he be called upon to
Yes.
testify, and should you allow us
yes,
to cross-examine him?
Yeah.
So we are
Yeah.
prepared, and I'm not
Yeah.
suggesting that we are.
to put questions to him as
Indeed.
opposed to cross-examining.
Indeed, indeed.
Okay,
So the last issue that I'd like you to consider, Chair, is this.
yeah,
That we have taken time to prepare for Mr. Van Rooyen's evidence and to complete Mr. Fuzile's evidence on the understanding that we will be beginning a new phase of the hearing, and that is
Yeah.
the ESCOM inquiry.
yeah,
The first witness of ESCOM will come on Friday. But before he comes to take the witness stand, we would like to ask you for time to take you through a number of documents.
Yeah.
And it's going to be a document-intensive exercise. We have set aside 2 days to do so. We are willing to give up one of those days in order to complete the outstanding evidence on 1.8. So that for that reason, we would be willing to start with the ESCOM's leg of the hearing on Thursday instead of Wednesday.
yeah,
And that additional 1 day can be made available in order to accommodate the complexities that arise from the delayed application for leave to cross-examine and testify. And so, Chair, that is a balancing exercise that we would ask you to take into account because, as you rightly point out, this commission does not have the luxury of time.
yeah,
The commission does not have luxury of endless resources. Time and the clock is always ticking, and is ticking against the context of a court order that we have at least not more than a year, 1.5 years to complete the investigation.
from March last year.
From March last
not
year,
from
Chair.
now.
From March last year. So that's a difficulty, and we
there was also the issue, but as you stand here, you don't know what the supplementary affidavit will say. So how can you say that you will be in a position to, you will not seek time to deal with whatever the allegations are?
No. I don't know what the supplementary affidavit would say.
Yes.
But I know what you asked him to say in relation
deal with.
Indeed.
Yeah.
And on that we are prepared.
Yeah.
Because he may give a version. And by the way, he has already given a version. But that version is not in a manner that you asked him to deal with. So
Well, I'm not sure. Maybe he did. You talk about the High Court affidavit.
Yes.
I do recall the statement that he wanted to see the cell phone records. I don't know whether he does anything more than that. You need not commit yourself to
No.
anything. You have read, you know what you want to deal with in due course in regard to that. Look, the only real issue from your point is Mr. Fuzile's evidence, or is it Mr. Fuzile and Mr. Van Rooyen's evidence?
It's both. The real issue for me is to complete the evidence of Mr. Fuzile, including his cross-examination by Mr. Van Rooyen. And thereafter is to have Mr. Van Rooyen testify and complete his evidence.
But didn't his counsel say he's not available today, or this?
I understand that he's not available today,
Yeah,
and I understand that they say he's not available tomorrow.
yeah,
But all we can say, Chair, is that we have indicated to them long ago
yeah,
in writing
yeah,
that these are the dates.
yeah.
And we leave it in your hands.
Yeah, no, let me hear. Counsel for Mr. Van Rooyen, what is his availability again?
Oh, by the way, I'm just been reminded by Mr. Mokoena
Yes.
that he indicated that his counsel can make himself available on Wednesday.
Oh, okay. Mr. Matiba?
Chairperson, just before I deal with that availability,
Yeah.
there's just a few issues that arise from Mr. Maleka, and I thought I should just deal with those very briefly.
Yeah,
Because I see that he says we're here because of the attitude that was adopted by my client, Mr. Van Rooyen. Now, we will deal, well, we've agreed that it will be dealt with in chambers.
well, you may be wanting to say, as far as the application for leave to cross-examine is
Yes,
concerned,
yes,
you were ready to move that application today.
yes.
Had it not been for the fact that the chairperson, you were told, wanted you to apply your mind to whether you should not deal with a certain issue.
Definitely.
Yes, otherwise you were ready.
Definitely, we're ready to move
Yeah.
it today. And as I indicated, the legal team of the commission had told us they're not going to oppose it. So,
Yes.
it's not fair, therefore, for Maleka to stand up here,
Yeah.
Mr. Maleka, then to say, they delayed by this period. But why are they supporting it if that is the case?
No, I think
they-
to be fair to him, he's raising that in the light of what is unfolding,
Yes.
arising from the fact that I have said I would like Mr. Van Rooyen to deal with the issue that we have. I think
Yes.
as long as the application for leave to cross-examine was dealt with today, and as long as Mr. Fuzile gave his evidence and Mr. Van Rooyen made himself available, he would have no problem.
Right,
Yeah.
yes. Then I think
Yeah.
that he should point to the right problem rather
Yeah,
than...
but what is his availability
Yeah,
again?
he's not available today and tomorrow.
Yeah,
Wednesday, he could be
Yeah.
available.
yes.
Yeah, but what Mr. Maleka didn't deal with is that we raised with them the fact that with regard to Mr. Fuzile, we couldn't prepare for his cross-examination as we're dealing with the supplementary affidavit.
Yeah,
And secondly, we have a statement that was given to us this morning,
yeah,
which we need to read through and see how it relates to outlined and advise him accordingly and consult.
yeah,
Yeah. So,
Yeah.
but that's why we had proposed Monday
Yeah.
next week
yeah,
for us to, for him to testify, first for us to cross-examine Mr. Fuzile, and secondly for him to testify and be cross-examined if the application for leave to cross-examine has been granted.
okay, no, that's fine.
Right.
Okay,
That's the context, yeah. Thank you.
Thank you. Well, I've heard everybody. We are going to postpone the application. I'm going to postpone the application for leave to cross-examine brought by Mr. Van Rooyen. A fresh date will have to be arranged, and it will be set down again. It's important that this commission be fair to all parties. The issue that I have raised and that I wanted Mr. Van Rooyen and his lawyers to deal with is an important issue. They were only informed of it late last week. There are other witnesses who come and give evidence and they don't finish, they come back. Ideally, we should be having witnesses where they come once and get cross-examined and they finish their evidence. Logistically, it has not been happening like that. I will allow Mr. Van Rooyen to have the opportunity to file his supplementary affidavit and let the legal team as well as Mr. Fuzile's team look at his supplementary affidavit and see if they want to file anything. A fresh date will have to be arranged. And I have already made remarks with regard to the fact that I understand that Mr. Fuzile is no longer with the government, is employed by new employers, but we just have to make sure that things are done in a manner that is fair to everybody. Unfortunately, he will have to be asked to come back at some stage. The application for leave to cross-examine brought by Mr. Van Rooyen is postponed, and in due course, arrangements must be made for that to be dealt with. And if need be, I will consider whether I can deal with it in chambers. I understand that all parties have, no party has a problem with that, to try and expedite matters. Okay, thank you.
Chair, now that Mr. Fuzile's evidence would not be heard today and tomorrow,
Mr. Fuzile's evidence can be heard. It's the application for leave to cross-examine that will not be heard.
Yeah. Mr. Fuzile has given a second statement. We received it on Friday.
Yes.
It does not affect any interest of Mr. Van Rooyen.
Yes.
I hope that you have been given that statement.
I have seen it, yeah.
And the statement mentions topics that are dealt with, and I'd like to take you through to some of them because it seems on the reading of the statement that a number of persons are mentioned, but are mentioned in the context of topics which have already been dealt with by other witnesses. And he raises two additional matters, both of which will be dealt with in due course and fully when our colleagues who are dealing with other state-owned entities present their version of the hearings. And so I'm going to take you through those parts in order to persuade you that on the reading of the statement, there is no need to give notice to persons who are mentioned because they have already been mentioned by others who have given evidence before you. And in respect of the two new matters he raises, notices to the persons he mentioned as possible implicated parties will be given to them in due course when full hearings on those aspects take place. But if you conclude that on the face of his statement, and with reference to persons who have been mentioned, there's a need to give notice, then the legal team will have to undertake that exercise. So can I ask you, first of all, to go to the statement, and it has not yet been given an exhibit.
Yes.
Number. What we suggest is that this statement be admitted as Exhibit P2 because
The statement, well, the entire bundle, the statement and annexures,
yes.
yes, okay.
Remember that his previous evidence was part and parcel of Exhibit P before you.
Yes. Yes.
So we would respectfully suggest that sequentially it should become Exhibit P2.
Okay, it shall be so marked.
And Chair, to take you to the various points of the statement, can I ask you to go to the second, the third page of that bundle? You will see that there is a table of contents.
Yes.
And you will see that there's an introduction. We can skip that for the moment. You can see that the second item, which starts on page 5, is his role at National Treasury. He has already testified about that earlier on when he took the witness stands on the 22nd of November. He then talks about the budget process, and then in on page 14, he introduces more or less a new topic, which is the attempts to move the budget to the presidency. It is at page 14, Chair. So can I
Yes.
interrupt myself and ask you to go to page 14?
Yes.
You will see that in paragraph 30 on page 14, he talks about rumors that he heard concerning the unhappiness of the former president concerning the budget process. And then in the next paragraph, he talks about the process that followed thereafter in order to remove the budgetary process from National Treasury to a different entity. And then he mentioned persons. But we have looked at that part of his statement. It does not suggest that either the former president or other persons he mentioned did something wrong to the extent that there was an attempt to remove National Treasury the budget from National Treasury to any other department or the office of the presidency. We would respectfully suggest that all of those persons he mentioned, they were mentioned as a matter of context, but not suggesting that they have done something unlawful, irregular, or illegal. And for that reason, we don't believe that there's a reason to give notice. But of course, like any other thing, it may be that we're wrong. To the extent that we're going to canvass this part of Mr. Fuzile's evidence, and to the extent that in the course of his evidence, he suggests that something untoward was done, then at that point in time, there may well be a need to give notice in terms of, I think, is Rule 10 of the Commission's rules. So that's the first new thing that comes about.
Yes.
if you go back to the index at the table of contents, you will see that from then he moves to the nuclear procurement, which starts on page 18 of his affidavit. That issue has been canvassed at length by both former Minister Nene and Minister Godhan. And all he does in that regard is simply to give corroborating evidence. We would respectfully suggest that his evidence on that score does not raise anything new.
So you say that other witnesses made statements and gave evidence that may have been said to implicate certain people in regard to that program, and those persons were given Rule 33 notices then.
Yes, especially
And,
Minister Nene and also Minister Godhan.
And actually, they, at least to my knowledge, they don't seem to have reacted in any way.
Yes.
Is that correct from the point of view?
That's my understanding.
Yeah, they have not
Yes.
considered that they wanted to put up a version or to complain about anything.
Yes. And my
Okay.
understanding of Mr. Fuzile's evidence here is that it is corroborating in nature.
Okay, okay.
And then he completes the corroborating evidence of the nuclear procurement at page 38. And from page 40, he goes to the next topic, which is the Engen Petro SA deal. You have heard on this issue the evidence of Minister Nene and the evidence of Mr. Godhan. His evidence here too is merely to corroborate the evidence. And at some point he says so in express terms. So we would submit that there's nothing new in that regard other than to provide additional source of information which you take into account in order to assess whether you accept the versions of the previous ministers who talked on this issue. And then next is matters relating to SAA from page 47. That's the second new topic he raises. But of course, you know that both Minister Nene has testified on it, and both Minister Godhan has testified on it. What is new in relation to the evidence of Mr. Fuzile on this is that he mentions persons by name. We would submit to you that to the extent that he mentions person by name on this topic, there's no need for us to give notice, because SAA, as you know, is a different topic which will be dealt with extensively before you by Ms. Hofmeyr, and she has been preparing on it. And once that part of the inquiry starts, relevant notices will be given in respect of those persons.
Well, to the extent that you say Mr. Fuzile's evidence today and tomorrow will be corroborative of evidence that has been given by other witnesses before, that on its own might not be a ground for or justification for not issuing notices, because what will be important is what the rule says, the relevant rule says. If the rule says if a witness, if the commission receives a statement from a witness that implicates a particular person, the legal team must give notice to that person, then whether it's corroborative or original might be neither here nor there, as long as it implicates the person. And indeed, somebody who might feel that they are implicated by the evidence of an original witness, if we can call the first witness to implicate somebody that they might feel that if somebody else comes to corroborate that, they should just have a right to be notified that there's somebody who is going to repeat or corroborate those allegations, and therefore they should be ready to apply for leave to cross-examine the witness who is corroborating another witness. You know. So it may be that what you are saying might not provide justification as such, but the fact that, but the conduct of the persons implicated in the evidence of the original witness in reaction to that evidence might well provide a basis for saying, well, maybe even if notice is not given ahead of the hearing of the evidence of the witness, that person didn't seem to be concerned about the allegations coming from the original witness because they've never applied for leave to cross-examine, they've never sought to challenge that evidence. Therefore, if somebody is just going to corroborate that, that might be their attitude as well, and therefore that might show or mitigate the position of not having given notice earlier, but maybe notice may well have to be given even if it's not ahead of the hearing.
Yes.
So that's the thought that comes to my mind at the moment,
Yes.
and you might wish to deal with. You might wish to finish what you were pointing out
Yes.
to. Yeah.
Can I get to the
Yeah.
issue now raised?
Yes.
And the conundrum for the legal team, and of course for you also, is this: that assuming we have to give notice by reason of what Mr. Fuzile says with reference to SAA, of course we will do so, and therefore he may not testify on this issue until persons concerned get notices and react to it. Or you may allow us to go ahead with this evidence despite the fact that notices were given late, as has happened, I believe, in
other situations.
In other situations.
Yeah.
It means that those persons, once they get notice, they will exercise the choice to apply for leave to cross-examine, and we will then play this game again. And persons with original knowledge and primary knowledge on those facts come in and testify, then notices will be given, and those persons will be cross-examined yet again on the same issue. We would respectfully submit that it is a conundrum which is inherent in the rules, but the rules are not there for the sake of it. The rules are there in order to make sure that you practically discharge your mandate in the most efficient way. In this case, the most efficient way is to allow Mr. Fuzile to testify without the need to give notices to those persons, because they're not prejudiced. As and when persons with primary knowledge, personal information, or personal knowledge of matters relating to SA come and testify, then they'll be given relevant notices.
You see, my inclination now is that Mr. Fuzile's evidence must proceed, but you must seriously consider at least saying to the persons concerned, your names are mentioned in this statement. The legal team takes the view that you are not implicated, so that if they want to make an issue of that, they still have a chance to make an issue and come before me. So I think that's how we have dealt with that situation in regard to another matter. So we don't make any decisions as to whether they are implicated or not. We give them a chance to have a look at the statement if they want to, and indicate if they feel that they are prejudiced. And if they want to make any issue about it, they can come before me and I hear what they have to say and we take it from there. So I'm I'm inclined to say we should proceed with Mr. Fuzile's evidence, but that you should consider making contact with them just to indicate what view the legal team takes, so that they have a chance to say, you are wrong, this is what this is our view, and then we take it from there.
Thank you, Chair. We're grateful for the guidance in that regard, and we will no doubt send appropriate letters to persons that are mentioned.
Yes.
And just to complete the chronology for you before we get to the body of the statement,
Yes.
you will see that he concludes the question of SAA at page 54, and then he starts with a related topic, which is the appointment of board members of SAA. And then the next new topic he raises is social security grant. Minister Godin had something to say about it. And then he moves on to the question of the closure of the Gupta bank accounts. That issue has been dealt with before you extensively, we would submit, by firstly the relevant chief executive officers of the banks who came before you.
Yeah.
It has also been dealt with by Minister Godin with reference to the application to the High Court, which he made and supported by the various banks.
Yeah.
So at best for him is corroborating evidence.
Mm-hmm.
And then the
Well,
last...
the social security grant, isn't that a new issue?
It is, but not... I think Minister Godin testified on this, if I'm not mistaken.
Okay. I guess with all of them, you, as the legal team, must just consider what I said a few minutes ago.
Yes, but again, as we go through his evidence, you'll see that he does not implicate any person.
Yes,
But
okay.
it may be that we're wrong. We'll deal with it.
Yeah, no, that's fine. It's just important to always go back to the rule, apply your mind to what it says, and then take it from there.
Yes.
Because the rules, and of course the regulations and the Commissions Act and the Constitution are things that implicated persons look at to see where their rights, what their rights are.
Yeah.
Okay.
And finally is the Danao VR laser deal, and we will deal with that when we canvass the body of his evidence. So, Chair, against the background of the table of content, we would like to get to the body of Mr. Fuzile's second statement, and I see that it is almost past 11:15. If it's convenient for you, we can adjourn and resume with the evidence after tea break.
Yes, that's fine, but it seems to me that contrary to what Mr. Fuzile and his new employers may have thought, it seems to me that with or without postponing Mr. Van Rooyen's application for leave to cross-examine him, it's likely that he would have to come back anyway if anybody who may be implicated in this statement applies in the future for leave to cross-examine and is granted leave to cross-examine. That's assuming that his statement can be said to implicate certain people, even if it corroborates what another witness says. I think what an implicated person would be entitled to if he's granted leave to appeal is, I want to cross-examine both. The one who makes the original allegations against me and the one who purports to corroborate those allegations. They wouldn't confine themselves to the original person. So I just want to mention that so that everybody is realistic in terms of what may happen in the future. Okay, we'll take the tea adjournment and we'll resume at 11:30. We adjourn. Yes, Mr. Maleka.
Chair, we're waiting for Mr. Fuzile. Oh, okay.
Okay. Zonaka, just administer the oath.
Please state your full names for the record.
I'm Lungisa Fuzile.
Do you have any objection to taking the prescribed oath?
No?
Do you consider the oath to be binding on your conscience?
Yes?
Do you swear that the evidence you give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, so help me God.
So help me God.
Thank you. Yes, Mr. Malega, you may proceed.
Thank you, Mr. Fuzile. Good morning and welcome once again.
Good morning, sir.
Yes. You have submitted a further statement to the Commission, and that statement has now been placed before the chairperson as Exhibit P2. I take it that you have Exhibit P2 before you?
Yes, I do.
Yes. Can I ask you to go to page 69 of Exhibit P2?
I'm there.
Is that your signature?
Yes, it is.
And can you confirm the date that appears on page 69?
15th of February.
Is that when you completed preparing the statement?
Yes.
I take it that you have read the contents of the statement.
A few times.
Do you confirm that what you have said in that statement is true to the best of your knowledge and belief?
Yes.
Right. You heard me taking the chairperson through the chronology of the topics that you discuss in your statement. They appear in the table of contents. You recall that?
Yes, I do.
And I'd like to go through your statement, bearing in mind that chronology. But let me clear first thing first. On page 2, paragraph 1 of that statement, you say that you consulted with the legal team of the Commission. Can I ask you, who did you consult with in the legal team of the Commission?
Well, maybe, Mr. Malega, for what it's worth, it might be important just to mention that actually the page on which the statement starts is marked page 2. So I assume that the table of contents is supposed to be page 1.
Indeed, indeed.
So when we refer to the pages, we'll just bear that in mind. That, yeah,
It's
okay.
that old typesetting where computers suppress the numbering of the first page and begin at page 2. I thought that these were outdated methods, but here we are again.
They are here.
Anyway, that will be, the table of contents will be page 1. If you don't mind, can you just mark it by hand as page 1? Back to the question. Do you recall who you consulted with?
I remember some of the names. Why is the name escaping me now? But it's is he Mr. Nene, this guy, or yeah? But I can check it on my phone. But I remember the names if I didn't expect you to ask them now.
Okay, but it's none of the
No, it's
members
none
of the legal team?
People here, yeah.
Okay, I just wanted to confirm that with you.
Mr. Fuzile, that mic
Is it too
pointing, well, not necessarily, but I just say it's pointing
In the wrong direction.
Yeah, so I think it should point towards you. Yeah, thank you.
Sorry about that.
Now I'd like to take you to page 4 of your, paragraph 4 on page 2 of your statement.
Yes.
And there you talk about some growing dissatisfaction when you were still the Director General of Treasury. Can I ask you to tell us more about that dissatisfaction? Who held the dissatisfaction you're talking about in paragraph 4?
Clearly, the president was one of the persons, and it does, I do say a few things about that later on in the statement to reinforce the view.
Yeah, who's the president you're talking about?
Former President Zuma.
Okay. And as a matter of your personal knowledge, were you aware of this dissatisfaction?
Yes,
Mr.
I
Maleka,
was.
You and I have read the statement, and he has read the statement. Well, I didn't finish reading it, but I've read quite a large portion of it.
Yes.
And we know what he says before he comes to paragraph 4. But whoever is listening doesn't know, so this dissatisfaction comes without any context. You might wish to get him to make sure that whoever is listening who has not read the statement understands what this comes from.
But that's what I thought I'm doing, Chair.
Well, you may be doing that, but the way it comes across, I'm sure, and I see some of the people in the room are nodding that they don't understand the
we'll get there,
context.
but first thing first, I mean,
Yeah.
Mr. Fuzile has to talk about matters that are within his personal knowledge. And I have
Yes,
to...
but he has in the previous paragraph said something that when you come to 4, you understand if you have read that.
Okay.
Yes, it's just that if somebody has not read that, even to me, when you ask the way, it lacks context, the
Let
connection.
me try again, Mr. Fuzile. What dissatisfaction are you referring to in paragraph 4 of your statement?
During my tenure and working under the ministers whose names are mentioned in the statement that will become apparent later on, there were projects, there were initiatives, most of which required either the concurrence of the Treasury or the approval of the Treasury at some stage to enable them to go through, some of which the Treasury or the respective ministers of finance either asked questions on or turned down, in other words, did not support or did not give the approval required. And it was that which, in large measure, gave rise to the dissatisfaction that's referred to in paragraph 4.
That gives the context. Yeah. Okay.
Thank you, Chair.
Thank you.
Then let's be clear, and I'd like you to be as clear as you can, and try to talk in direct terms, and less so through indirect speech. So who was dissatisfied about National Treasury?
Definitely President Zuma, and I said this in even the previous testimony. And one got this in a number of ways. First, for instance, I indicated in the previous testimony that someone said, I might have a new minister soon. I do refer to some of that in a different way this time around. And this was on the occasion, as I referred to in the previous testimony, when the CEOs of banks, when I was still in government, I just happened to be in a role like that now, but it was when I was still in government, had a meeting with the president of the new BRICS Bank, and then someone pulled me aside. I remember I made a mistake last time. I said pulled me apart. Pulled me aside, and which carries quite a different meaning.
Well, it does.
Yes.
In more ways than one.
Yes.
Because maybe there might be implicated persons who might wish to pull your evidence apart.
Exactly.
Yes, Chair. You must wait until you get cross-examined.
Yes, maybe
You
they
may
will
well understand the meaning of
pulling
pulling
apart. Thanks, Mr. Malaga. And I could see in your reaction that time that you were trying to tell me that I shouldn't hurry. The time will come for me to be pulled apart. I'm waiting for that to happen. It's not going to be easy. But let me just say, then someone had pulled me aside. He said, look, you will have a new minister soon. I said, but why? And they indicated, made reference to this dissatisfaction.
Yes.
And there were a few other instances, but I don't want to waste the time of the commission talking about it.
In paragraphs 4.1 to 4.7, at page 3 of Exhibit P2, you do identify several causes of what you conceive to be dissatisfaction. I'm not going to waste time by asking you to repeat them, because you deal with each and every one of them at length. So if you don't mind, we will deal with them when we get to each of the detailed...
Well, I think, Mr. Malega, it won't take much time for him to just indicate the headings which he has indicated.
Yes.
Then whoever is listening can follow. When he deals with them in detail, they can connect. Yeah.
Right. Do you want to deal with them just by
Just to say what they are, that's all.
I'm at your service.
Yes, let's get through them quite quickly.
Yes. No, I will. I mean, it was the nuclear procurement project, the purchase of shares in Engen by Petro SA, the matters relating to SAA, a few approvals, the social security grant contract, the General Asia matter, the closure of Gupta accounts by banks. Those are the ones that I list here as examples.
Yes.
Well, well, maybe I can also say this, Mr. Malega. To the extent that we have got his statement, if he covers as much as he can in his oral evidence what's in the statement, it enables one to make sure that when one reads the transcript, one doesn't have to go to the statement. You just read one, and because everything is covered, then you don't really need to also read the statement to refresh one's memory.
All right.
Yeah, thank you.
All right. Mr. Fuzile,
But you may deal with it the way you see fit, as long as you understand that the substance. It doesn't need to be everything, but the substance. No. Yeah.
It will be a laborious exercise. So please, if I do rush, apply the brakes and emphasize some aspects of your statement which I may skip over, if you don't mind, because it is your statement, it is your testimony. You have dealt with and identified the various topics of concern that gave rise to the dissatisfaction. And can I ask you this? Why would those issues give rise to that type of dissatisfaction? What was so unique about them as to give rise to a dissatisfaction?
These were big, most of them. They were, let me say, significant. in fact, if you just take an example of something like the nuclear procurement, I can't think of any other project that the South African government has ever embarked upon. Certainly not in the 25 years or so post-freedom of the magnitude of nuclear. I mean, estimated by some generous conservative estimates to be about $1 trillion. It could be a few percentage points higher than that. So it's very, very significant. Trillion, if you take it as a proportion of the size of the South African economy. So they are big projects, very weighty projects. They involved a lot of money. It stands then to reason that when the people in the Treasury, the Minister of Finance, were just doing their job, were asking the tough questions about these kinds of things, people would get frustrated because they wanted to see them to the end, in other words, the commitments being made, and we felt that such significant commitments required very thorough due diligence, evaluation of their affordability, not only in the immediate term, but in the longer term, detailed assessments of their impact on the fiscus in terms of affordability again, but also just the impact on the entire economy and different constituencies in that economy. If you take something like nuclear again, it has got to be paid for in the final analysis, or in large measure through tariffs. Tariffs affect every household. They affect every business. So you can't approach a decision that relates to that cavalierly, if I were to use the word. So we were insisting on thorough processes. Of course, I would submit that for some of these, it would seem that people had other interests other than what is supposed to just inform how you approach these kinds of decisions.
Yes. Now, in paragraph 5.1, you say that the Ministry of Finance and Treasury became a stumbling block to the erosion, and in parenthesis, you say corruption of due process in policy and decision-making in the state. I'm intrigued by the word you put in brackets. What do you mean by that?
If you just take procurement, I mean, our legal frameworks take the matter of procurement very seriously. The fact that it is mentioned in 217 of the Constitution that every procurement process, and I'm not quoting this verbatim, but it must be transparent, it must be fair, cost effective. There are a few things that are mentioned there.
Yes.
So what we then were insisting upon was that the processes as prescribed in 217 of the Constitution and reinforced by a series of other legislations or pieces of legislation, such as the Preferential Procurement Framework, the PFMA, and the regulations that go with those, that we should follow those processes as they were prescribed there. And it was evident, as the statement does show later on, that at different points there was temptation, proclivity to try to cut corners, to try to avoid certain processes that are prescribed in law. And we had to insist on those for a variety of reasons. But chief among these is the fact that these commitments were huge, And the reason the law is written the way in which it is written, it is to make sure that the processes that are followed produce the most optimal outcome. Because if you invite, for instance, as many bidders as you possibly can, then you have got the possibility to choose the best. So when you then narrow the range of bidders from whom you choose, right from the beginning, you are in fact corrupting the process. You are eroding elements of what is provided for in law and regulations.
All right. And you say in paragraph 5.2, I don't want to read it, but I'd like to sum up what you say, then ask you for a comment, that any bad decision made on those major projects would have dire consequences that would burden future generations with debt. I wonder whether you are able to explain for a layperson like me how a bad decision on a procurement, say for instance, of a nuclear project, would give rise to such burdensome consequences for future generations.
If you just take, again, the nuclear example, and there is a presentation that is attached here as an annexure, which shows, for instance, in one part, how both the debt of the South African government and potentially guarantees would have been impacted under different kinds of assumptions by nuclear procurement. In other words, we try to show in that presentation, under assumptions that we make very transparent, by how much government would have had to support, for instance, whichever entity would have ultimately been chosen to implement nuclear, with some equity first, because there was no entity with a balance sheet large and strong enough to be able to support the raising of the amount of debt that would be required. So the first thing is that government would have had to inject the cash. Now government, most people, not most, let me not be rude, some people think that it's got a lot of money that's sitting somewhere. It just takes and it can put in for instance, Eskom or Nexa. But it would have had to raise that money through borrowing. That's the first bit, impact. The second bit would have been then in future years to enable whichever entity it was to raise more debt, government would have had to provide guarantees. It's public knowledge now that Eskom on its own cannot raise the kind of money that nuclear would have required. Then it would have required the support of the sovereign. We show again here by how much the guarantees would have had to increase. And of course, the servicing of the debt that's on Eskom's books, or Nexa, if it was going to be the implementer and operator of the nuclear power stations, would have had to come from tariffs, because that's the one source of revenue that Eskom has. So that's where the notion of the debt then burdening South Africa's future generations. It's both what is in the sovereign's books and what is on the entity that would have been running those nuclear power stations, having to get the revenue from tariffs. Yes. So that's what one is referring to here. The amounts are huge. The amounts are huge. I mean, if you just view them against the backdrop of the increases in tariffs that there have been since the mid-2000s. I mean, like one of the newspapers this past weekend just carried the figures. Yes. They are staggering because it's like multiples of 10. Now, the tariffs would have had to increase quite significantly going forward. I would contend that it doesn't matter which option one would have chosen to fund these power stations. Short of another generous country choosing to donate it to us, the bed into service that would have been huge.
You might be able to deal with this now, or you might deal with it later when you deal with the annexure to which you have just referred. If South Africa had committed itself to the nuclear program and had signed all the agreements that National Treasury was opposed to, what would that have done to other national issues that require money for the country? You can deal with it now, or if it's more convenient, you can deal with it when you deal with that annexure. But I would like at some stage to know what you say about that. Yes, Mr. Malega.
Okay, can we just, if we can, deal with it at the moment? And can I ask you to go to a document which begins at page 132. And I see that the document has been marked secret. You disclose it as part and parcel of your statement. I suppose we don't have to pay too much attention to the characterization of the document as secret. It's now before the chairman in open hearing. Yes. And the heading of the document is Modeling of Fiscal Implications. Correct?
Yes.
And you were modeling the fiscal implications of the procurement of a nuclear power station of a particular size and capacity in terms of its ability to provide energy. Correct?
Yes.
Now, on that issue, do you recall what was the estimated nuclear plant or plants capacity in terms of energy generation, which you were modeling?
We modeled two scenarios. We did the maximum amount that was contemplated, which was 9.6 gigawatts. And then we also did a smaller scenario which was predicated on a modularized approach to the procuring of nuclear, which started with 2.4 gigawatts. And we wanted to see the differences in the impacts of the two on the various fiscal metrics and, of course, affordability.
Yes. In fact, if you go to page 135,
Yes.
In paragraph 8, you do state as part and parcel of the modeling exercise that you were dealing with a 9.6 gigawatts
Yes.
of a nuclear plant or plants.
Yes.
And for some of us who don't have an understanding of these complex engineering concepts, and who have some kind of knowledge about at least one nuclear plant that we have here, which is Kubek.
Yes.
Do you know what is the size of Kubek's gigawatts capacity?
No, I don't know.
You don't know? Okay. All right. I won't mislead you. But anyway, that was the size that you were considering. And then you talk about the costs of it from 138, in terms of the debt burden of it, in terms of the cost of it as a ratio of GDP. These are typical technical terms, and I wonder whether you would be able to explain them to us with reference to some of the graphs that appear, at least from page 138, so that the chairperson is able to follow precisely what you were doing and what message you were trying to send to the policymakers.
Yes. Just now, we're starting in the middle of it, but let me try my best with it. Essentially, one, we made assumptions about the size of what we're going to buy. 9.6 gigawatts versus 2.4. Second, we made assumptions about the costs per kilowatt, as you see on the left-hand side there. And of course, we had to make assumptions that there are no interest payments, which is sort of simplifies the modeling, so that you make assumptions about the overnight costs of procuring the nuclear. Third, we made assumptions about GDP growth, because you will see, Mr. Chairman, that some of these measures, we do them relative to GDP. In other words, we express the debt as a percentage of GDP, we express the guarantees as a percentage of GDP. So we must then make assumptions about the rate at which GDP is going to rise or expand over the next several years. Now, perhaps let me put just emphasis on this. We were assuming, by the way, that the growth rate would be between 2 and 3% for most of these scenarios. And if you look at the recent past, our economy has had the difficulty realizing even 2%. So that alters these matrices because in a way, the debt component would have been what it is, because simply because your GDP is not growing fast, whoever sells you the stuff does not say, okay, let's sell it cheap now, because the price is not indexed to GDP. You have locked it in contract,
Yes.
but all of a sudden your GDP is small, all of a sudden when you express this debt and your guarantees as a percentage of a smaller GDP, it becomes much bigger. Just a point.
And just to clarify there,
Yes.
I mean, your model begins at year 2016.
Yes.
And you will see that you model it horizontally across up to
Yes. 2040.
2040.
Which is sort of roughly some 20 years on, you can say.
Yes.
And then,
sorry,
sorry, continue. Okay.
my apologies.
Is that okay? Yeah, no, it's fine.
That gives you the time and space of the period you cover, from 2016 projecting forward to
Yes.
2040, in case some of us live that long. And then on the vertical side,
Yes.
you express percentages of possible economic growth. Is that correct? Or
Look,
not?
No. It's on the one at the bottom. It's the debt as a percentage of GDP. The one at the top, it's debt and the guarantees, and they are different colors, although they are not obvious here with black and white. We put the nuclear debt at the bottom, I think, as a sort of lighter gray. That's what it would add to the existing guarantees. Am I making sense? There are existing guarantees already in the system.
I understand that.
Yeah.
So for you to build a nuclear project,
Yes.
you'd have to issue
Give
new guarantees.
extra guarantees to whichever entity is going to build the power stations, whether
Yes.
it's ESCOM or NEXA.
I understand. In other words, assuming it is NEXA, NEXA will have to go out to the market to raise capital.
Yes.
And government must back up that debt by means of guarantees.
Yes.
Okay, we understand
It is.
that.
So what you then see is sort of projected drawdowns, if we just stick with the guarantees.
Yes.
Once we have issued a guarantee, let's use an existing example, 350 billion guarantees issued to ESCOM.
Yes.
It doesn't mean that on day one, ESCOM has raised debt equal to 350 billion.
Yes.
It just means that ESCOM, in some of these technical terms, has got headroom, has got the ability to raise debt totaling 350 billion on the back of that guarantee.
Yes.
In other words, people can see through the weaknesses or poor rating of ESCOM and look instead at the sovereign as the backer of the entity. So over time, this is what we estimated they would draw down in guarantees over the life of this project, with that peak around 2030. In other words, that's the maximum point at which both the guarantees and the debt would be. And beyond that point, because the building of the power stations would have been completed, all you are doing now is to amortize the debt over time. So it's the guarantees at the bottom, then at the top, it's the actual debt. In other words, where either the entity itself, in this case, we're assuming it would be the sovereign helping the entity, would have to take up that more debt.
All right. Then you draw a conclusion. I'm at page 138.
Yes.
And it's a conclusion that the judge will be interested in. You say the combination of nuclear debt, nuclear guarantees, and baseline debt results in an unsustainable debt path, reaching in excess of 75% of GDP by 2030 and continuing to rise. You confirm that that's the conclusion you had expressed?
That's the conclusion we had expressed, Mr. Maleka. So in a way, what we were arguing was that on an assumption of a growth rate in GDP of between 2 and 3%, I keep emphasizing this point because it does determine the affordability, because that's your base.
I understand that.
And it's important whether it's the sovereign or ESCOM, by the way, because if there is no growth, then there is no demand for the electricity, then there is no revenue to generate and therefore be able to pay for the debt. So you can see, if you look at the bottom graph, those lines that's pointing up, which show that the debt would rise from the base to anything between 75 and 95. And of course, the graphs are still pointing upwards. They are not beginning to level off by 2040 from that bottom graph.
Yes.
What decreases are the additions to the debt. And sometimes people then make the mistake of thinking that when the additions to the debt decrease, the debt itself is decreasing. That's not necessarily the case. You can reach a peak where the amounts that you add cease to be big. In other words, as you see in this graph, that the highest addition is around 2030, thereabout. The addition to the stock of debt starts to fall.
Yes.
But it doesn't mean that the debt itself is falling. All that it means is that it is increasing at a decreasing rate.
Yes. Right. And you give the figures with reference to 2030, and those figures are at page 140. And the peak there...
Before that, Mr. Maleka, Mr. Fuzile, the part of page 138 that Mr. Maleka referred you to which you have just talked, should we read that, the word before debt, as unstable, or is it supposed to
Unsustainable.
be unsustainable?
Yeah.
Okay.
Unsustainable.
So we should
Sorry.
amend it.
Yes, it's unsustainable.
Okay. Thank you, Chair. And then you then give the 2030 estimates about this unsustainable debt path on page 140. And there you will see that the percentage rise of GDP is 90%.
Of debt.
Of debt.
Yeah.
And that's
As
a
a
peak. That's
percentage
the
of
highest it could reach if you go on this procurement.
It isn't, sadly. I wish it was.
Oh,
I wish it was.
all right. What
We
happens
stopped the modeling at that point.
at 2030?
Yes. Yes. I mean, you can see in the graph, if you look at the graph at the bottom, it is still pointing up. That's why I was illustrating this. Yeah.
All right.
So, if it was going to be, if this would result in a debt that was in excess of 75% of the GDP in 2030, I guess that you are simply saying it was out of the question, or not really.
Look, not really. These things, this is the difficulty with these things, because it's not like science. With all the risks, let me, for instance, illustrate that there are countries whose debt is more than 100% of their GDP. What matters with debt is what you used the money that you incurred the debt to do. But it's also then a whole lot of other dynamics which include the structure of that debt. What do we mean by the structure of the debt? It's maturity profile. Do you have repayments that are very big at given points in time? So big that that's what got Greece into trouble. I hope that there's no problem with me mentioning a country like that. Because at a time when the global financial crisis broke, Greece happened to have very high, as we call it, maturities. In other words, debt, service cost, interest, and capital that they had to settle. So all of a sudden, lenders said, we don't believe that if we give these people money, in other words, if we allow them to refinance that debt, to roll it, they will be able to repay it. So then they refused to give them the money. And when you are at that point, that's when your debt has trapped you. That's when you need the market to have confidence in your ability to continue to service your debt, to be able to keep it. So I do not want to, for instance, say here, there's science that when you reach that point, the scales would have tipped. But the truth of the matter is also that when you get to that point, and another graph does show this here, that just the sovereign's own debt repayments reach about 80 billion at one of those years.
Yes.
Now, when you then overlay this on top of that, that's what makes it unaffordable.
Of course, we know that, I'm sorry to interrupt you.
Yes, that's fine, anytime.
There is a policy position adopted by Cabinet, which Minister Godan and I believe Minister Nene testified on, about the debt ceiling which this country has adopted. Are you aware of that?
I am aware of it. There's a convention in SADC which says that preferably countries should try and make sure that their debt as a percentage of GDP should not exceed 60%.
And Minister Godan confirmed that that was the position.
Yes.
As at the time when he was still the minister.
Yes, no, it's a broadly accepted position.
So we could not go out in the markets and borrow money which was in excess of 60% of our GDP.
We would be breaching that convention to which we have subscribed.
Indeed, it's a policy position. In the context of that policy, and forgetting about Greece, but talking about South Africa, if we had gone ahead with this nuclear procurement, what would it have meant to that fiscal policy on the debt ceiling of that kind?
No, certainly it would have meant that we breached that debt ceiling. What it would also quickly have taken us to, by the way, which is a very important anchor for fiscal policy, is to cause our country to breach the expenditure ceiling that government had set for itself, which we thought was an important anchor for confidence in our ability to manage our fiscal affairs because lenders were beginning to be a bit jittery about our ability to manage our affairs. So we said, look, trust us, we will not allow spending to exceed this particular ceiling. And we normally just allow expenditure to grow marginally above inflation to set a new ceiling over time. That one would have been breached by now if this program had started, say, around 16 or 17, without a doubt, with these amounts.
Yes. Right. Then you draw some conclusions and make recommendations. And I'd like to take you to that part of your modeling exercise where you draw some conclusions and make some recommendations. They are at page 148.
Yes.
And can I ask you to summarize them for us so that those who don't have this document would be able to appreciate the import of those recommendations?
I mean, if you just look at the first one, we were saying that it would be wise for the South African government to avoid contracting for 9.6 because the modeling does suggest that it's not affordable. Instead, go for that modular approach, as I was saying, contract for a smaller portion first, execute it to its conclusion, and then you can go for the next phase. Second, we were making the point that it would be important to make sure that if you look at a thoroughly considered process of procurement, very transparent, that begins with undertaking a feasibility study and looking at whatever legislative amendments might be necessitated by this. What we had as an example in relation to the legal stuff, so that it's not just legal what it's standing out there, there was a contemplation to have NEXA being the builder and operator of these power stations. Now, currently, the law doesn't allow NEXA to do that. They are predominantly a kind of research outfit and so on. So we were anticipating that there would have to be a process to legislate for that. And of course, we list in a few things that would have had to be considered to make sure that the litigation risk wouldn't occur. In fact, it's common cause now that, for instance, those treaties that had been signed were found to be, I hesitate a lot to use these words, I don't know whether illegal or unlawful, but in any event, they didn't pass the legal muster.
Yeah, we leave that to the Cape High Court.
Yes, in B, we were saying that to mitigate the fiscal risks, in other words, all of these things that we've talked about insofar as affordability is concerned, it would be good to first make sure that the fiscal consolidation process that government had set itself to start takes root. In other words, the stabilization of the debt of government, exclusive of helping whichever entity would undertake nuclear, must be bedded down, must be clear that we are succeeding to control our debt. Then you embark on this new program that will see the debt rising, not overlay it with a new thing. And of course, C is not very different from what I said in A, and D is about just managing the thing over a longer period of time and so on and so forth.
Yes. I mean, on these conclusions,
Yes.
there would not be a possibility of procuring a nuclear plant of that kind because there had to be a completion of fiscal consolidation.
Yeah.
And that would have happened a year later in 2017.
Under some assumptions, and it hasn't happened, by the way, without nuclear. just to be clear. I mean, we know from unless this new budget pulls something out of a hat, whatever the phrase is, but we know from the October budget that the deficit path that was proposed still sees the deficit at about 4% of GDP. That's quite significant. It's not consistent with the fiscal consolidation that we talk about.
So on any premise, you were telling policymakers that it's impossible to procure.
Yes. It's important, though, to make this point, which is the angle to this submission that I make here, which is that this thoroughgoing presentation, there was an attempt not to go through it in as thorough a way as we are even doing here. And precisely because it was saying things that people didn't like. That's the point I was making about the corruption of process. Here, and perhaps it's another point to make, a very, very important point. It was not only the Treasury that was insisting on following good process and due process. The Department of Energy, as the statement says earlier on, had found a way to get to Cabinet with the recommendation to approve that it proceeds to procure nuclear, or nuclear procurement should proceed. But in Cabinet, some members of Cabinet did say that, look, we cannot approve something like this without knowing what it means in terms of its cost implications and how we're going to pay for it. So go back and talk to Treasury, work together to show us that as a country we can afford it, which created the opportunity then for this work to be done. Yes. Notwithstanding that, there was still an attempt to suppress it or to make sure that it doesn't get seen, but we will talk about that.
Chair, I believe we've exhausted this issue, and
Yes, I think you have, yes.
Your concerns would have been adequately addressed by Mr. Fuzile. We were at page 4 of your statement, and I respectfully suggest to you that from paragraph 9, you are telling us about things that you had previously canvassed in your evidence. I'm not going to ask you to repeat it. Yeah. And also, when you go to page 7, when you talk about the role of the Director General of National Treasury, you
that was dealt with last time.
Indeed.
Yes.
Unless you have something that you would want to share with us.
No, not at all.
Not at all.
Most of it, we can skip it.
Then that takes us to page 14 of your statement.
Yeah.
And sadly, you start about the question of rumor, about the concerns which you heard concerning the budget process. And you talk about the DG of the Department of Planning, Monitoring and Evaluation, who had something to say about that rumor. Do you want to develop that theme for us in your own words?
Yes, I had a conversation with Mr. Mate, and I thought that this is later. It's on 36. This bit just deals with the presentation that was done by page 14 at the bottom, from 30 downwards. Just deals with the presentation that was done at a FOSAD, Forum of South African Directors General, by 3 colleagues. And the reason for raising this is to just point out at 2 things. First, the fact that the budget process does give rise to dissatisfaction for many people. And it is to be expected because most people would like to do too many things than the country is able to pay for.
Oh, yes.
It is rare that even in any household, people start by trimming what they wish for to fall within what they can afford. So it's just that kind of a problem. But it then creates fertile ground for this kind of resentment, which when the authorities, people like the president of a country, then feed into it, your Department of Finance and those who are charged with running it are in trouble, actually. That's the essence of this, because they don't have that air cover where people say, no, but they're doing their job. We have got to spend what we can afford. So I'm putting that here, where we can have colleagues, some of whom, by the way, which is the irony of this, were participating in the very process of making the budget, but we're also joining others when they say they are dissatisfied with it.
Yes.
Then go to the DG of Presidents in the Presidency and the National Planning Commission from 34 downwards.
Yes.
Mr. Kulegani Mate.
And you say that he talked to you about that rumor for the first time in November 2015?
Yes, yes, Mr. Murray. So he talked to me about that, yes.
All right. And can you just summarize what was the upshot of the discussion you had with him on that score?
Two things. First, then there was a process within the Presidency which used the National Planning Commission to ask that they should assess whether the budget is aligned to the priorities. And one contends that, that, by the way, was strange because no one had come to us to say, look, this process, we don't think it does this, or can you make an assessment, or can you show that the budget is aligned to priorities? That's the first thing. And connected to that, as a sub-point, was just what appeared to be a real, I don't want to suggest anger, but I don't have a better word, which came from the president, which in 39, I use his own words. He said they must give him the evidence. If the evidence confirms that the treasury is failing him, then he will shake the tree. If it must fall, so be it. At which point, I asked Kulegani what he understood this to mean, which takes me then to the second point that I would make on this, without belaboring the point. He said, look, he thinks that maybe the president was readying himself to fire the Minister of Finance and some of us. Right? This is what he said to me.
Yeah, but that's at the level of rumor. That's
Yes.
The president did not tell you that, did he?
No, he didn't, except that he did it not long afterward.
No, we understand. We can draw some conclusions from it. But as far as you know, sitting
okay.
as you do in
Yes,
the witness
yes.
stands,
Okay.
he did not tell you anything to that
No, he
effect.
didn't, yeah.
Yes. And the final point which I'd like to raise with you on this score, because it may become important for the direction the chairperson might make on us, to us, is this. In the ordinary course of events, is there anything wrong with the head of state raising concerns with you as National Treasury about the budget process?
No, not at all, except that there is a difference between what you are saying and what is said here, and I know that you know it. You're saying that is there anything wrong with the president raising
Yes.
his concerns?
Yes.
There is no problem at all.
Okay.
We do this on his behalf. What is strange is when, in essence, the president presides over the budget,
Yes.
right? The budget that gets tabled every year gets approved by a full cabinet. And sometimes parts of it, like the division of revenue between the spheres, is approved by extended cabinet, which brings in premiers of provinces and organized local government. So the budget process is not the preserve of the treasury. The budget is not the preserve of the Minister of Finance. It gets approved through those structures. And there are structures under that, but I won't bore you about them.
Yes.
So there is no problem whatsoever with it. What is strange is when people who run a process are unhappy with it, and then they don't just say fix it, for example, and they try ways that are hard to explain to do it.
In effect, what you are saying this, that what is strange is when a person who is part of a particular forum and processes if he or she is unhappy about some things, going outside of that forum to raise concerns.
That is precisely
Is that
the
what you are
point, Mr.
saying?
Chairman.
Yeah. Okay.
Right. Mr. Fuzile, unless there is any issue you want to raise in relation to the budget process, the rumor you heard, and the attitude of the then president, I would like to move to the next topic, which begins at page 18.
I'm with you. I'm on 18.
Are you at 18?
Yes.
And just to make sure that you understand what 18 deals with. It talks about things that occurred when you were still the DG relating to removal of ministers. And for the record, can you confirm who those ministers were?
It was Mr. Gordon, Mr. Nene, and I would say Mr. Jonas as well as the deputy. And Mr. Gordon was removed twice.
Was removed?
Twice.
Okay. He has testified on that score. I'm not going to ask you to repeat what you say. In fact, in paragraph 42 of your statement, you refer to aspects of the statements of Mr. Godan and aspects of the statement of then Minister Nene, which you confirm and corroborate, correct?
Yes, I collaborate, yes.
And I'd like you to then go to page 19, where you talk about your position as the DDG for assets and liability management. And you said you were chairing the Fiscal Liability Committee, and there certain things happened. I don't want to put words in your mouth. Can you discuss for us what happened when you were still the chair of the FLC?
The FLC, Mr. Chairman, is a committee of Deputy Directors General, which are people just a level under the DG. I think it has got about 6 or so of them. It looks, for purposes of this submission, at, among other things, the guarantees that government extends to entities. It is normally chaired by the DDG, who is responsible for assets and liabilities, a job I occupied for about 2 years or so, from 2008 July. And during the time I was part of the FLC, not only just the time that I chaired it, it's important to clarify, we had occasion to approve 2 guarantee applications for Eskom. The first one for about 176 billion, and the second one, which was the difference between that number and 350 billion, which was meant to increase the guarantees to Eskom, to enable Eskom to be able to raise debt, because the markets, as I indicated, are beginning to have doubts about Eskom's ability to afford that debt on their own. Of course, there are 2 other things that happened. One is that government had to give Eskom a subordinated loan of about 60 billion around that time, which was later converted into equity, because again, the balance sheet needed some propping up. Yes. Subsequent to that, and there was also a further injection of equity totaling 23 billion into Eskom. The relevance of these things is that it is in that context that the procurement of what is a substantial program was being contemplated. So you've got this entity whose balance sheet is quite weak, and people then on the other hand are contemplating that it should be part of procuring something as big as nuclear.
Yes. You talk about government subordinated loan of 60 billion rand in Eskom. And you say at some point, well, we know what subordination means. It means you back rank your right to claim that amount as a creditor until other debts have been paid to other creditors. But you say at some point that was converted into equity. Do you know when was that debt converted to equity?
I would hesitate to say under oath.
Well, we'll ask Eskom if you can.
Yes, but it was after around 2013, 2014, thereabout.
2013, 2014.
Yeah.
All right. And the effect of it is to try and improve your balance sheet.
Yes, because you sort of, although already a substantial proportion of it was recognized on the books of Eskom as equity, but now the effect of converting it to equity is that the full extent of the amount is recognized as equity, and it changes most of the ratios that are worked out on the basis of equity versus debt.
All right. And on page 20, you draw attention to two tables in order to illustrate your point. I confess that I don't understand those tables, but if you want to clarify them for us, that will be helpful.
You will understand very quickly, Mr. Malek. I've seen you go through stuff. Essentially, the first table sets out the total debt of government over a period from 2008-9 to 2017-2018, right?
Yes.
So that's at the top, it's the time. The first then line with numbers is gross loan debt. That means it is all the debt that government has.
In real figures.
In absolute terms, right?
Just mention them for us, please.
In millions? I see there is
Billions, Chair.
R millions or what?
Yes.
What is that R millions?
It's very important, yes. Now, once that R million means that when you read the 626,975,
The first figure.
the first number,
Yeah.
it is 626 billion. Because if you add 6 zeros to that, then that number becomes a billion. Am I making sense?
Yes.
Otherwise, if we were to write all the digits,
Oh, okay,
the table
yeah.
would go out
Okay.
the door.
Okay.
So it's a way of simplifying. So whenever you read those numbers,
Yeah.
just remember that 626,975, it is just 626 billion.
Yes.
Yeah.
The next one is 804 billion.
Yes, yes.
Okay.
Just continue like that.
And then it gets to 2.5 trillion.
Then it gets to 2.5 trillion when you get to 2017-18.
Yes.
Right?
Which
And
is
that's
a-
debt. That's not, there is no error there. It is debt.
These are real figures.
It is,
so that
yes, now you will notice economists hesitate to follow you when you say real figures, because real might mean in our case that you have excluded inflation.
Okay.
These are absolute figures. In other words, they are what they are
Yes.
Yeah.
when you are looking at them.
Yeah.
Yeah.
Now you may think that when you say real, it's just okay, but I will not follow you because
That's fine. But I mean, you're giving a figure which is an absolute number.
yes,
Referencing the previous financial year.
Yes.
To understand how much we as a country owe the world.
exactly.
Yes.
So if you go, for example, to 2011, 2012,
Yes,
that first column,
yes,
you have got 1,187,790. That would be 1 trillion, is that right?
yes.
187 billion,
Yes.
and then the rest.
Then it's 790 million and da.
Yeah,
Yes.
okay, all right, thank you.
Yes.
Now, the essence of this table, then the next line is net loan debt. In other words, you take out cash. Because if government has got cash in the bank, right, very easily, if it's called upon to settle its debt, it can take its cash and pay it. And therefore, just to show the true picture of the indebtedness of government, you've got to show that they've got the cash. Now, the essence of these figures, without boring you, is that they show just the trajectory of South Africa's total debt stock over this period, that it rose from 626 to 2.5 billion to 2.5 trillion by 2017-18.
Yeah.
It's a huge increase. Now, this is not to blame anybody. I spent a lot of time...
It's simply to state a fact.
It's simply to state a fact, Mr. Chairman, and it's also to paint the picture that says, as we were thinking about nuclear procurement, this is what was unfolding in front of us.
Which
So,
you were aware of at the
Which we
time.
were aware of at the time. And then if you go back to the graphs or the exhibits that Mr. Maleka meticulously took me through, you would add that debt on top of this for some of those graphs.
Yes.
Except the one at the bottom, because the one at the bottom which was showing debt as a percentage
Yes.
of GDP, it was adding on the
Yes,
base.
yes.
But the other ones at the top, you would add on top of this, which
Yes.
is why we came to the conclusion that the debt would become unsustainable.
Okay, thank you.
The last issue that I'd like to plot on that score, just to make sure that the chairperson has a full picture of those figures, is the next table,
Yes.
which talks about the revenue side of our country and the expenditure side. And the revenue side is substantially taxes. You generally, when you prepare a budget, project estimation of the tax which SARS is going to collect.
Yes.
And then on the basis of that, you project an expenditure from all the departments and state entities, and you draw a balance. I'd like to reflect on 2 financial years. The one is when this nuclear project was being conceived in 2015 and 2016 financial year, and ask you to comment on what was our financial health as a country in relation to the revenue and expenditure side.
Around that time, Mr. Chairman, you would notice that our total revenue, for example, 2014-15 was 965 billion. Our total expenditure was a bit higher than that at 1.131 trillion. So what that then means is that we have got a shortfall, which is that negative 166, pardon me, 166. That is what is called the main budget balance. In other words, the difference between the taxes you collect in that year versus the expenditure in that year.
Budget
That translates you to the amount that you have to borrow to finance the shortfall in a given year.
Right.
And expressed as a percentage of GDP, and that's very significant actually, is that 4.3% of GDP at the bottom. Because that's the number that then signals when people, if you just check after Wednesday, is it Wednesday that the budget will be tabled?
Yes.
I can assure you there will be headlines that refer to the budget deficit. It's a very significant number in signaling the state of health of the fiscus. If the number stays high at 4% or some figure higher, then it means that your fiscal consolidation, in other words, your reining in of debt, slowing the rate at which you accumulate debt, but not slowing the debt itself, but at least you adding little amounts or decreasing amounts over time. It means you are not succeeding if that number is increasing or is constant. And lenders like it when that number is falling, because it demonstrates that you are managing your spending to get closer to being within the revenue that you're raising in a specific year. You are getting closer to a point where you are going to be living within your means. Because that line, you can say it's a reflection of living beyond your means, actually, simply put. You can only collect so much revenue from your economy, but you spend more than that. It's not a crime, but
it's not good.
it would be better not to have it.
Yeah.
Okay. The last financial year is the previous one, 2017, 2018.
Yes.
Again, reflect on the money we receive and the money we spend through the budget process estimation and the difference as a deficit.
Then in that year, it pops up. This deficit, if I may go straight now to the number, is 217. And that 217, expressed as a percentage of GDP, is 4.6. It is almost a full percentage point higher than the year before, which is the 3.8. Which then means, instead of fiscal consolidation, what you're getting is you are adding increasing amounts as a percentage of GDP. As I was saying, the opposite, then people who lend you money start to frown at this and sort of get concerned that you are not managing your affairs, fiscal affairs properly. And these are some of the reasons why then the rating of the country by rating agencies drops. And of course, it translates to a whole host of things that have been ventilated here previously.
Right. So to conclude on this point, Mr. Fuzile, on your figures, 2014-2015 financial year, going forward to 2017 to 2018, we have not been able to control our spending.
Well, we have not succeeded to effect fiscal consolidation.
Which is a complex and complicated term for inability to manage and control your debt.
I would agree with that.
Now we go into the next topic. And again, here I should remind you that two other witnesses have already testified on it. And with your permission and the permission of the chair, I'd like to move quite quickly on it, if you don't mind. We do so against the context of the numbers that you have conversed. And you start at page 49. You talk about your discussion with Ms. Nelisiwe Magubane, and I'd like you to expand on that because it's a matter that you have personal knowledge of.
I think as you said,
Paragraph
49
49. Paragraph 49.
Paragraph 49,
Yes.
yeah.
I'm sorry about that, Chair.
I indicate in the statement that Ms. Magubane, who was the DG of Energy at the time, gave me a call and he said that he needed some advice. Before her, she had a proposed agreement between South Africa and the Federation of Russia, or Russian Federation, whichever is the appropriate way to say it. Her concern was that the agreement was making reference to tax incentives or favorable tax treatment of the nuclear procurement with the Russians, and she didn't think that she was empowered to deal with that. And of course, I indicate that I gave her my preliminary view on this, which was that our law is not very flexible on matters of giving tax exemptions. South Africa's system is decidedly legalistic. You've got the taxation law and we've got Tax Administration Act. Issues of exemptions, you can't just give them willy-nilly. And I made reference to how difficult it was to give some of those exemptions to FIFA, even though they were demanding that they get them everywhere. We gave them a bit of a runaround because there are careful considerations relating to why it is not advisable to give those types of exemptions. But then I made the second point to her, which was that I was concerned that they were at the point of signing an agreement with one country, and I was hearing about it for the first time. I said to him, having been here all along, I would have thought that given just the requirements of our constitution and all other legal prescripts, the country ought to be knowing about the fact that there is a procurement process for nuclear that has gone as far as signing agreements. So I said, but she should send me a request formally to do, which she dutifully did. And of course, we then had correspondence in which, for instance, I was indicating to her just how we were thinking about this and how unwise it would be to proceed as they were contemplating. The important point to perhaps make on this is that this is one of those agreements that there has been a finding, maybe there's an appeal against it, I don't know, in the Western Cape.
What intrigues me is why Ms. Magubane would come to you when we have a lawfully established body such as SARS, whose domain it is to deal with questions of tax incentives.
Yes. No, there wouldn't be anything wrong. Remember, SARS is the tax administrator.
Yes.
But the policy on taxes is done by Treasury, and if there are to be any considerations of the kind that were contemplated here, and the decision on the legality or otherwise, it would still be within Treasury and the Minister of Finance. But the enforcement of what is in law and has been agreed or exempted is SARS's business.
Oh, I see.
Yes.
So you were the frontline policy-making body on
Yes, no.
questions of tax incentives.
Yes.
And SARS was the second line of administration.
Yes.
I understand. What was the upshot of all of those discussions you had with Ms. Magubane now that she had made available to you a copy of the agreement?
Look, one, it was that the process had gone a bit far and was not consistent with the legal prescriptions of South Africa. Just even the process of procurement, one. Two, the contemplated tax incentives were inconsistent with our law. And we pointed this out to her.
Yes.
And of course, I learned later on, as I indicate on paragraph 54, that the agreements were signed with those favorable conditions.
Yes. But the upshot of it is that you as Treasury had not contributed anything in relation to the agreement that was presented to you ultimately.
Yes, we hadn't.
Now, you take the matter further on page 23, on paragraph 56, and introduce that development through a telephone call you got from Mr. Mukhajani. At that time, we know he was the chief of staff of Minister Godana. What happened after you received that call?
The minister and I availed ourselves for the meeting with, the call was inviting us to a meeting with President Zuma at his residence on an afternoon, on a Friday afternoon. We proceeded as asked. We ended up there. When we ended up there, we first were ushered into a room where we met a gentleman whose name I mentioned in the submission, Mr. Sandy Tobejane, who introduced himself to us as the advisor to both the President and the Minister of Energy on energy matters. And of course, because the President was out of the country, he was returning from, I think, Angola at the time, we had to wait. And whilst waiting, we had a longish conversation with Mr. Tobejane in which he was just taking us through some of his thoughts on nuclear, which is what he said, he thought maybe the meeting was going to be about, explaining then the different technologies as I captured that on 63.
Yes.
And then at the bottom of page 24, you will see that I refer to this sort of proposed approach to procurement that was being contemplated, which refers to the first stage where there would be a decision on the countries that would potentially provide nuclear, and then the next stage would be for those countries to compete amongst themselves.
Yes.
And of course, we did sort of hint at our reservations about that approach to procuring nuclear and its consistency or otherwise with Section 217 and all other relevant prescripts of the law. I do make the point in 65 that Mr. Chobejane sort of explained all these technologies and the countries that they were offering. And he tried to be objective, but I couldn't help but detect that when he came to Russia, he liked their technologies and stuff like that. And I mean, he's a nuclear physicist, as I learned later on. And I don't want to even try to pretend as if I understood those technologies. I'm just a mere economist, a rusted one, nohal. But he explained this, and you could tell. Now, maybe not. I mean, I suspect that I was looking at what he was saying against the background of those agreements that Ms. Makubane had talked about to me. Of course, needless to say that the president then arrived and the conversation kind of continued. Mr. Gordon did tell him that we have had some conversation. Mr. Chobejane has told us a few things about nuclear and so on, which the president indicated he actually wanted that to happen. That's why the meeting had been called. Then I make the observation towards the end on page 26, which was that Minister Gordon just made those comments about two comments. First one was that if, and he was very emphatic about the if, deliberate about it, that if South Africa were to continue with the idea of procuring nuclear, it would have to follow every rule in the book, were his words kind of, because failure to do so, and I'm paraphrasing, would turn, and this bit is his own words, would turn the arms deal problems into a Sunday school picnic, which I found quite instructive. I mean, he made that point. And of course, he asked that to avert a situation like that, Mr. Chobejane and I, as technical people, should sort of talk to each other and make sure that we can help ensure that the procurement process was in line with the relevant laws. I will end this by just saying that something perhaps that, I mean, not perhaps, that I don't touch on here is that it was strange, by the way, to have this conversation with an advisor. Because advisors in departments, I indicated in the previous appearance here, they don't have signing authorities over things. The DGs are principal chief advisors to ministers. The executive authority is with the minister. The accounting duties or responsibilities are with the DG. They can delegate to people under them. Nowhere does it make provision for delegating to an advisor or that interface. Advisors play important roles, but it was a bit odd for me that we had the conversation solely with the advisor from the department, but it happened that way.
Fair enough. You've talked about that at length with reference to Cabinet Special Dispensation in terms of Section 12A of the Public Service Act. Chair, I see that it is just past 1. I wonder whether this is a convenient stage.
I think this may be the convenient time. So, as that meeting ended, what appeared to have been the purpose of the meeting, as you understood it?
I asked Mr. Gordon, I said, but what was the purpose of this meeting? He kind of gestured the queer way, but it's, I mean, I think part of it, I mean, what the president communicated was that, look, the reason he called with his sort of nuclear procurement has got to proceed and it's got to happen, kind of expedited. That's the one thing. But I also think that just given the kind of approvals that are often necessary in government that have got to go via Treasury. Take, for instance, the tech stuff here. And you will see when we get to the SASA issue that I mentioned that, you know, when you want to deviate from procurement process, you've got to ask the Treasury. There is always then this when people look at things, they say, but where can the glitches be? And
Yeah.
Treasury looms large, and then, signaling to them. I hesitate to use the word nudging, because if you sort of, call us to a meeting, you say, look, this thing, you've sort of, without necessarily forcing, but you've signaled
Yeah.
how dear you hold the project, and therefore soften the people. I don't know, because
Yeah.
there was never a stated purpose before the meeting, at the meeting, or after the meeting.
Yes, but it does appear that the president may have wanted that there be a discussion in his presence initially between Treasury and Mr. Tobejane in regard to various views, and then maybe later on they would have those discussions later on. But initially, it seems that he needed that they come together.
Yes, that's quite a generous interpretation, Chair. And one can say it is. I mean, I would have understood, in a way, if the people who were supposed to do the procurement, facilitated, as in the Minister of Energy, the DG of Energy, or the DDG relevant for nuclear. You know what I'm saying?
If they were there.
Why would you jump to the people who might have to approve something at some point down the line and say the thing must happen fast?
Okay.
It's a kind of
Okay, I understand.
a queer approach.
Okay, we'll take the lunch adjournment. It's now 1:05. We will resume at 2:05. We adjourn.
Thank you, Chair.